the United States of America, the state of Tennessee, and this honorable board. Please be seated.
Welcome to a very special court docket for the Tennessee Supreme Court. Thank you all for being here. It's a privilege for the Tennessee Supreme Court to hold court proceedings in this historic Supreme Court chamber in our magnificent capital. This is an historic occasion, a homecoming of sorts for our court. The Tennessee Supreme Court held its court proceedings in this very room for about 3/4 of a century, until 1936, when the Supreme Court moved to the fancy new building down the street. We hope that you enjoy some of the historical facts put together for this occasion with assistance from Jeff Sellers with Tennessee State Museum, my law clerk Hannah Fuson, and our wonderful AOC staff. You'll see a poster outside with facts about the court's history in this room, and on your chairs there should be a timeline of the Tennessee Supreme Court and its time in this room. Governor Lee, you grace us with your presence here. We thank you for facilitating our being here. We thank as well all the legislators who have come here to see our court. We honor the work that all of you do on behalf of our state. This day celebrates all three branches of Tennessee government, all under the magnificent lantern atop our splendid Capitol, all doing the people's work. It demonstrates how we all work together on behalf of the people of Tennessee. Governor Lee, you should see three especially familiar faces on the bench today who demonstrate our three branches of government at work. Justices Campbell, Tarwater, and Wagner were appointed by you and confirmed by our legislature. We are thrilled to have them on the court, and we thank you for your appointment, and we thank the legislature for their wisdom in confirming them. Governor, would you like to say a few words?
Thank you very much, and to all of the justices. For me to stand in front of them is an honor, and in front of you. And I'll just say a couple things about the importance of even what's happening today. It seems very, it's very significant. 75 years ago or so, the court was actually held here. It will be actually held here today. The legislature is in session. The governor's office is alive and well down there. I can say. We actually will be signing a bill into law today. There is work being done from all three branches of government, as was said earlier, in this building. It's historic, it's important, and it's actually government at work on behalf of the people. I see school kids in here all the time in this Capitol, and I remind them how unique our country is, how the founders, how brilliant they were when they established this government of three separate, we have members of the General Assembly here, three separate branches of government, equal branches of government who don't always agree, but find a way forward to govern the people that they represent, which is the beauty of this whole system. And I've come to appreciate the value of it in ways that I never imagined before I came into this into this office. The opportunity that I have to appoint members of the judiciary and the confirmation process that happens with the General Assembly, the way that we all have to work together in making sure that the people of this great state are served is, I have a deep appreciation for it. I especially have a deep appreciation for the people sitting behind me on this bench who make us all very proud in this state. We have the highest caliber of justices to execute justice on behalf of the people in our state. So real proud moment and historic moment for me to be here today. And I'm really glad every single one of you are here too. Regardless of the role you play and what's happening here is important. I'm glad you're able to see it. Thank you for giving me a minute to speak.
Thank you, Governor Lee. Well, we will segue now to the court proceedings. Mr. Hibner, I'll let you get everything set up. What you will see are real court cases being decided by the real Supreme Court with a lot of real questions. All right, this is for those on the live stream, this is the February 12 afternoon docket of the Tennessee Supreme Court in a very special setting at the Tennessee Capitol. We're very pleased to have all of you here to watch our court proceedings. Mr. Hibner, are there any preliminary matters before we begin?
No, Your Honor.
You may call the first case.
Brian Coblentz et al. Versus Tractor Supply Company.
No pressure, Mr. Carter.
Good afternoon, Your Honor. May it please the court, Rick Colbert here on behalf.
Sorry.
No pressure, Your Honor.
Sorry about that. Okay, good one. I've known him for probably 25 years.
I'm here on behalf of the plaintiff, appellant Brian and Casey Coblentz. I'd like to reserve 5 minutes of my time for rebuttal. This is a case that arises from an injury Mr. Coblentz suffered when some barn door rails at a Tractor Supply store in Fayetteville, Tennessee fell and struck him in the head. It was a pretty significant injury that he suffered. He was in the store in his role as a Stanley National sales representative. Stanley sells goods, hardware to hardware retailers all over the country. And Stanley and Tractor Supply had a contract with each other titled a vendor agreement. It's in the record, and the record's in about 5 volumes. It's in volume 2 of the record at page 228. Exhibit A to that agreement was a 15-page list of all the different things that Stanley sold to Tractor Supply. Mr. Coblentz's job for Stanley was to go to the different stores in his areas. He hit each store about once every 4 to 6 weeks. He would check Stanley product inventory levels, and if the level of a product was low, he would order more. He didn't deliver it. He didn't set it out for display. He just ordered what was needed, and he left. Now, if there was a Stanley, a little piece of hardware hanging under the wrong tag, like you see in a Home Depot or whatever hardware store you may frequent, if it was a piece of Stanley hardware, he'd move it under the right tag. If there was trash in a Stanley display, he'd clean up the trash. But otherwise, his job was really just to order more inventory for the store. The store had its own people to put the inventory out on display. Tractor Supply has its own merchandise presentation department. And if there was something that Mr. Coblentz saw that he thought was unsafe, it wasn't his job to fix it. Tractor Supply had its own safety officials to do that. He would notify the store manager if he saw something that looked unsafe. After he suffered this injury, he obtained workers' comp benefits from his employer, Stanley National. The case has been around a long time because it took him a long time to reach maximum medical improvement from this injury. And so this underlying personal injury case really was stayed until he got to that point. And then this case proceeded, which was a personal injury case for premises liability against Tractor Supply. And the trial court, and was affirmed by a majority of the Court of Appeals, determined that Tractor Supply should be treated as Mr. Coblentz' statutory employer under Section 50-6-113A of the Tennessee Code. And because of that, Tractor Supply was immune from tort liability for Mr. Coblentz' injuries. The primary issue before this court is whether a vendee in a vendor-vendee relationship, a vendee like Tractor Supply, should be treated as a principal contractor and therefore as the statutory employer of its vendors' employees under the provisions of the workers' comp law. And
Mr. Coblentz, if I could interrupt you there, I'm wondering whether, to rule in your favor, particularly under this, under Judge Usman's analysis and his dissent in the Court of Appeals opinion, would we need to overrule or abrogate any of our previous decisions?
No, I don't believe you would, Your Honor. I think I call them the Murray and Lindsay test. Those are the cases from this court where the court has pretty clearly laid out I guess the three things, the three tests to determine whether an entity is a principal contractor and therefore a statutory employer for purposes of the Act. I think that test is a worthwhile test in the type of contract that was contemplated when the statute was enacted a century ago. It just doesn't fit a vendor-vendee relationship. And so what we are suggesting to the court is you have to look at the nature of the relationship and decide whether that's the right test for it or not. And we believe that in a vendor-vendee relationship, just like in a landlord-tenant relationship, for example, if you had a landlord who leased space to a tenant and the tenant then subleased the space to a subtenant, would the landlord then be the statutory employer of the tenant's employees? It just doesn't fit in every situation, and it doesn't. The Murray and Lindsay test doesn't fit in a vendor-vendee relationship.
Mr. Colbert, let me follow up on that then, and let's assume for a second that we disagree with you that there needs to be a new test, and we decide to apply the three-factor Murray-Lindsay test. Does your client lose in that situation?
Well, not necessarily, Your Honor. I mean, I think we had an argument in the Court of Appeals and I don't think anybody disputes that the first two prongs of that test don't apply, and the majority in the Court of Appeals said that. They looked at the third prong of the test, which is what they found that applied. And the question is the work being performed by the subs employees part of the regular business of the company, the principal contractor, if you will, or the same type of work usually performed by that company's employees? And we contended that it wasn't in this case because Tractor Supply's employees had no means to order Stanley. I mean, this employee ordered Stanley parts. Tractor Supply had no means to do that. They had to contract with Stanley to get that done. They couldn't just call up Stanley and say, send me some barn door rails, send me some more screws and bolts or whatever it is Stanley might sell to them. They had to use a Stanley salesman to get those parts. The Court of Appeals obviously disagreed with us. Even Judge Usman thought the Court of Appeals was right as far as it went. They just shouldn't use that test. But we would obviously disagree with that. But in reality, we don't think the court should go there. So,
but as you pointed out, even Judge Usman in dissent agreed that if the three-factor test were applied, your client would be considered a statutory employer.
That's right. That's right.
Or excuse me, TSC would be the statutory employer.
TSC would be the statutory employer. That's right.
How significant is it, Mr. Colbert, that this is mean, you point out in your brief that there wasn't really like an ascending or descending relationship here.
That's right.
It really is a relationship that's different in kind from the typical contractor-subcontractor relationship.
I would call it a collateral relationship.
Yeah, I mean, how significant is that? And I would point you specifically to, there's a 1945 case called McVeigh, which involved the furnisher of some materials on a construction site. So it was similar to this case in that, they're selling goods, providing goods to another entity, but, so I'm wondering whether you think we would have to abrogate that case in part, or whether there's some way to distinguish that, perhaps based on, this, like, is it an ascending or descending
I don't know that the question. I don't know that the question necessarily has to be asked that way. Is it ascending or descending? I mean, we point that out. We think if you look at the terms in the statute, which the legislature didn't define for us, they talk about a principal contractor and a subcontractor, and sub, I'm pretty sure, is short for subordinate. So I do think there was, when the statute was written, there was this concept of what you would see on a construction site, a principal contractor who has parts of the job done by subordinate contractors. And that's consistent with the purpose of the statute, which this court has said over and over, is to make sure principal contractors hire responsible subs who have workers' comp for their own employees. And this ensures that those employees are covered if the subcontractor doesn't. But if you go to and we've cited a bunch of them, and Judge Usman cited a bunch of them, if you go to the other states that have squarely confronted this issue of a vendor-vendee contract, which we don't think this court has, they all look at, all the cases involve some level of service. There's always some level of service involved. And the courts, I mean, I can string cite you the cases. There's the Meyer case from South Carolina, Hammock from Oklahoma. It goes on and on. There's a Kansas, Arkansas, Kentucky. And they all look at whether the services provided were merely incidental to the sale of goods, or whether they were substantial services that went beyond that incidental level. Even in Judge Usman's dissent, he cited a Colorado Court of Appeals case in a footnote that he said was an example of a court coming out differently, where in a vendor-vendee situation, they did apply their statutory employer statute. But if you read that case, it was the Humphrey case. The court distinguished another Colorado case, Doyle, and in the Doyle case, there was a general contractor who had a construction site, and they hired Ready Mix to bring concrete out and to pour it. And the court said, no, the pouring, the delivery and pouring of the concrete was merely incidental to the vendor-vendee relationship between the general contractor and Ready Mix. So we're not going to apply the statutory employer statute.
So doesn't that suggest that maybe McVeigh would come out differently?
Well,
I mean, that sounds an awful lot like the facts of McVeigh. I mean, we don't have a lot of details about the facts of McVeigh. It was a pretty sparse description, but.
Yeah, the facts we have about McVeigh are abbreviated, I guess, if you will. But I think, again, I think it would be a fact question that the court would have to look at instead of trying to apply the Murray and Lindsay test. I think the court would just have to look at the facts and
Well, aren't you just really saying, yeah, Justice Campbell, you'd have to overrule it?
You have to rethink it. So,
I mean, what would you, I mean, do you think, should we just kind of set that aside as that issue is not before us, and, we're not going to take a position on whether that would come out differently under this test? Or, I mean, should we overrule that?
I don't think you have to overrule it, but I don't think you have to overrule it, because I don't think it squarely confronted the issue that's before you now.
But what's different about that situation? I mean, what is materially different about what we have here? I mean, in both, you've got, you know, a vendor selling goods, selling materials to a vendee, right? With
Right,
some
but-
incidental provision of services.
Well, I think here, that's, I mean, it's about as incidental can be. This is a sales rep who comes to a store, checks inventory levels, and orders more if they're low. It's hard to imagine anything any less substantial than that level of I mean, you really can't even have a vendor-vendee agreement without at least that much. But, I mean,
So are you saying that a vendor-vendee situation just should never be a subcontractor, or are you proposing a different test?
well, there may be a level of service that accompanies that vendor-vendee relationship where it would make sense to treat the vendee as a principal contractor under
So
this.
you've used the word incidental. Are you saying that the test should be whether the provision of service of a vendee is incidental or not?
In the other state court cases from other states that have squarely confronted it, the terminology they've used is substantial services. If there are substantial services that are rendered in conjunction with the vendor-vendee relationship, then they will find that there is a principal contractor and subcontractor or statutory employer relationship.
What
But-
do courts look at to make that determination? Is it just within the four corners of the agreement, or
No,
do you
no,
look
it's
at the
not.
parties'
It's-
course of dealings as
It's
well?
it's the course of dealings, it's the facts. It's really, I mean, I think the agreement may matter, but the language in the agreement may matter, but I think they look at the totality of the facts to determine what services are actually provided. We have suggested that this really, it really shouldn't be dissimilar from the analysis that the courts in Tennessee do already use. We talk in our brief about the predominant purpose test, which the court uses in situations where you have a contract for, it's a mixed contract for sales and services, and the court has to decide, are we going to apply Article 2 of the Uniform Commercial Code to this contract, or are we going to analyze this contract under regular contractual, common law contractual principles? And the court, and we cited the Court of Appeals case in the Tanzer case, where the court outlined the four, we think, very common sense factors that are used in that predominant purpose test to decide, is the predominant purpose of the contract the sale of goods, so it's covered, we're going to interpret the contract and apply the Uniform Commercial Code, or is the predominant purpose the provision of services? And they do look at the language of the contract. They look at the nature of the business of the supplier of goods and services. They look at the reasons that the parties entered into the contract, and they look at the amounts that are paid for goods versus the amounts paid for services under that contract.
Mr. Colbert, I'm sorry, I didn't mean to interrupt you.
Go right ahead.
Aren't you asking us, though, to create an exception, to narrow the scope of the statute, to carve out a particular relationship that's actually not in the statute? On what basis would we do that?
No, I don't think I'm asking the court to narrow the statute at all. The statute, the words of the statute are a principal contractor, intermediate contractor, or subcontractor shall be liable for compensation to any employee injured while in the employ of any of the subcontractors of the principal contractor, intermediate contractor, or subcontractor, and engaged upon the subject matter of the contract to the same extent as the immediate employer. What we're asking the court to do is decide whether a vendor-vendee relationship fits within the terminology of that statute at all. And we don't believe it does.
And which terms are you saying that they're not a contractor or a subcontractor subcontractor,
We-
or what are you?
Your Honor, we don't.
Don't say any of them. You have to tell.
No. In a vendor-vendee relation, just kind of a straight vendor-vendee relationship without substantial services, we do not believe that the vendee should be regarded as a principal contractor and the vendor should be regarded as a subcontractor.
Okay.
And they're not engaged upon the subject matter of a contract, other than the contract for the sale of goods.
But there is a contract, right? So, I mean, how do you reach that conclusion textually?
Well, I mean, what is the contract that the statute is speaking of when you're talking about how we're going to apply this to a principal contractor and subcontractor? I think the legislature, when they wrote this statute in 1919, I believe, was probably speaking of things like construction contracts, road contracts, those sorts of things. If Tractor Supply and Stanley National have a contract for the purchase and sale of goods, who's the principal contractor and who's the subcontractor? The only contract they have is this collateral contract with each other for the sale of goods. It's not they're not engaged in some contract for some third objective that they're trying to serve beyond the sale of goods. It would be sort of like telling somebody that runs the market down at the corner that for the USA Today delivery person who brings the paper and sets it in the racks, and whoever brings the Miller beer and puts it in the cooler, or the Coca-Cola and puts it in the cooler, and whoever puts the Little Debbie snacks out on the shelves, those are all your, those companies are all your subcontractors, and you've got to now pay a workers' comp premium and be ready to provide work comp insurance coverage for every one of their employees who walks inside your store, even if you didn't do anything wrong. Even if they just came in.
So you're saying that the statutory provision should apply only to contracts that involve the provision of services, not provision of goods?
The sale of goods, that's right.
But where do you get that from the text? Do you agree with, I mean, Judge Usman engaged in a pretty careful statutory analysis in his dissent and, pointed out that, I guess, typically contractor and subcontractor are defined in a way that kind of contemplates certain work that will be performed, that it's not so much, a collateral agreement for the sale of goods, but, that it's about sort of work being performed under the oversight or supervision of another entity. I mean, do you generally agree with his statutory analysis, or do you have a different view?
I do agree with that, and I think the Supreme Courts in all the other states who have dealt with very similar statutes and have said that they don't apply to vendor-vendee relationships unless those relationships are accompanied by substantial services. I think they see their statutes the same way, that when their legislatures have talked about principal contractors and subcontractors, they're talking about work that's being performed, and they didn't contemplate that a simple sale of goods would be encompassed by this statutory provision.
But the mere distinction between a contract for services versus a contract for the sale of goods is not really the determinative factor, is it? Because you have to consider all the underlying facts involved in the situation. I thought, because you said earlier, you're looking at the entire factual scenario.
You
right?
are,
Yeah.
you are, and I think the courts in all those cases did that. I mean, they looked at if you look at the Meyer case out of South Carolina, that was the question was whether Piggly Wiggly grocery store was the statutory employer of a baking company salesman who brought baked goods in and put them out at the store. And the court looked at what did that employee do when he came to the store. He stocked, he pulled old stock, he cleaned up the bakery display. The court looked at all of it and they said, those aren't substantial services. This is principally a vendor-vendee relationship, we're not going to treat Piggly Wiggly as the statutory employer of this employee of the company that sold baked goods to Piggly Wiggly. Same thing in the Hammock case. It was a PX, and there was a Miller Beer route salesman who brought in beer and put it in the cooler at the PX store. And the court said the principal object of the agreement between the PX, or it's the Army Air Force Exchange that ran the PX, and the Miller Beer people was the sale of beer. And that's a vendor-vendee agreement, and the services rendered were not substantial. They were just incidental to the sale of beer.
Is there a meaningful difference between the substantial services test that was applied in the Piggly Wiggly, South Carolina case you mentioned, and the predominant purpose test? And if so, do you have a view as to which one is the better test?
I don't think there's a meaningful difference. I think we offered the predominant purpose test because it puts it gives you some more specific things to look at when you're trying to make that decision about whether these services are substantial.
But you think they're getting it the same? I mean, the aim is the same in both predominant
think the
purpose.
aim
It's
is
just a little more detailed.
The aim is very much the same. And you know, the aim of the predominant purposes test really is the same. It's to figure out, is the primary purpose of this contract the sale of goods, or is the primary purpose the provision of services? And we think that's a very good fit with the legislative intent behind this statute, which is not to saddle everybody out there who's involved in the sale of goods with dealing with this work comp and immunity issue. It's to make sure principal contractors are responsible and don't try to avoid their responsibility by subbing work out to people who aren't going to provide coverage for their employees.
So if we were to decide this case strictly on the language of the statute, engaged upon the subject matter of the contract to the same extent as the immediate employer, would your answer be the same, that we should use a predominant purpose test, or we should use some other test to try to discern the subject matter of the contract to the same extent as the employer?
I think my answer would be the same, but I just don't think this statute was intended to cover a vendor. I mean, I didn't make this up. Larson's is sort of the leading work comp treatise out there, and they state very clearly in there that these statutory employer provisions that are in work comp laws all around the country were not intended to cover every type of contractual arrangement. And they mention lessor-lessees, and they mention vendor-vendees. They specifically mention it in the Larson's treatise.
We were going to give you credit, Mr. Coblentz, for
I wish I could take the credit for being so brilliant, but I just can't do it.
But that said, what we have is the language of the statute, right? The legislature didn't give us Larson's. They gave us the statute in 1919.
But that's right. But it's up to you to decide what's meant. I mean, this is what the court does all the time. The legislature didn't define for you what is a principal contractor, what is a subcontractor under that statute. It's up to you to decide that.
Well, we're capable. Some folks would say it means what it says what it means.
Well, I respectfully submit that the terms are not broad enough to apply in every possible contractual situation. I think I may be into my rebuttal time. So.
You are, but I'm not going to call time on it, Justice, so.
All right.
Thank you, Mr. Colbert.
All right.
Good afternoon, Your Honors.
Good afternoon.
My name is Colton Jones, along with Marty Cook at counsel table, the law firm of Spencer Fain, on behalf of the defendant below and the appellee here, Tractor Supply Company. And what an honor it is to be in this setting. I didn't expect all this fanfare, so it's really a special.
It's all for you.
Yeah. If my mom's watching, she would say yes, absolutely. Absolutely. Well, first off the bat, I'd like to talk about this court's oral arguments that it held in at Austin P a couple months ago. And Chief Justice Kirby, you asked the newest justice, Justice Wagner, to say a few words to the students there. And it was basically a rehash of Civics 101. And I watched that video, and I thought Justice Wagner did a great job of rehashing the three branches of government. She said that, we have the executive branch and the legislative branch, and those branches are more political. They make policy decisions and they pass laws. And then we have the judicial branch, which is headed by this court. And she said that the judicial branch is not political. We do not make policy decisions, but we uphold the Constitution and the laws passed by the General Assembly. And if the court does that today, then it will have done what Tractor Supply is asking, that this court refrains from making a policy decision, but instead defer to the General Assembly as to whether the statutory employer rule under Tennessee's Workers' Compensation Act should be interpreted and applied differently. And specifically, this court should decline to carve out an exception like was discussed during the last 30 minutes with the appellant. Don't carve out the exception, because that's what would be required for vendors of retail stores, thereby removing them from the rules coverage.
Why
And
is
we're
this a policy change and not just a plain language interpretation of the word subcontractor, like Judge Usman said?
Because it would narrow the scope. I know that question was asked of appellant's counsel, but it would definitely reduce the scope, and it's easy to see why. Take this case, for instance, where you have Mr. Coblentz was injured. They're trying to argue that he was, it's a vendor-vendee relationship. He's not the statutory employee. So, all right, what if you have people that are situated like him? They're injured in the course of their employment. They're on the premises of another company like Tractor Supply. And in this case, let's say that he didn't work for a good company like Stanley National that carries workers' comp insurance. Let's say he works for a smaller company and they provide a little bit of product and they don't have workers' comp coverage, or they don't have adequate coverage. And he files a claim against his immediate employer. They can't cover the expenses, and so he goes up the chain to Tractor Supply. Under their proposed rule, Tractor Supply would not be a statutory employer, so he files suit and tort against Tractor Supply. And in this case, it was dismissed on summary judgment on the premises liability negligence claim also. So he can't prove his negligence claim against Tractor Supply. He can't recover from his immediate employer, and he can't recover workers' comp under Tractor Supply either. So he'd be left empty-handed. And I think it's important to point out that in this case, we have a situation where everyone's heard the term, a bird in hand is worth two in the bush, right? And the implication is that, it's a lot of times it's more favorable to take the sure thing, one unit of a sure thing, rather than going for double of an uncertain thing. And in this case, Mr. Coblentz has the benefit of having that certain thing already. He's already recovered workers' comp against his immediate employer, but now he's going for the two birds in the bush also. He's trying to recover in tort against Tractor Supply, where future workers that are similarly situated as him, they wouldn't have the bird in hand. They'd have to go double or nothing.
I think we've gotten a little astray from what we started talking about, which was the statutory language. So I'd like
Sure.
to take you back to that.
Okay.
And I'd like for you to point out what specifically about Judge Usman's statutory analysis in his dissenting opinion in the Court of Appeals you have a problem with. I mean, where did he go wrong if your view is that the terms in the statute are correctly interpreted, are broad enough to include this vendor-vendee relationship?
Right, and I think Judge Usman, he had some fair points, but the one thing that I think he maybe glossed over a little bit was the term subcontractor in TCA 50-6-113, rereading the subsection A. A principal contractor, intermediate contractor, or subcontractor shall be liable for compensation to any employee injured while in the employ of any of the subcontractors. So that word, if you're in the employ of one of the subcontractors, the court in McVeigh would have to be overruled. They said that a subcontractor is all-inclusive, and it includes vendors, it includes,
Does it include Amazon? Does it include just a relationship where the sale of goods is done by delivery of a package?
That's a great question.
Does it
I thought you might ask
involve,
that.
I mean, how far do we go in saying that the vendor-vendee relationship is equivalent to principal-contractor relationship? Is it just a salesperson who is there once a year and does no services at the location? Is it one who just happened to be in the neighborhood? Or, I mean, how far do we go? That language, Judge Usman indicated that the contractor language indicates the performance of work. Sale of goods feels different to me than the performance of work. So I specifically want you to address that.
Sure. Well, the first part of your question, does it apply to Amazon or I guess any sort of delivery service where it's dropping off, a package? I would say that it depends on whether what they're dropping off and providing the principal contractor is a regular part of their business. So, to use opposing counsel's example where you have the newspaper stand, for instance, if that stand primarily sold newspapers and that's what the business that they were in, if they're receiving deliveries of newspapers, then that's probably a very regular occurrence. It's a big part of their business. Someone's got to do it.
But really, if that's all they're doing, they're just dropping off a crate of newspapers once, well, newspapers, it would be a little more often, but, let's say it's a business that sells a variety of things, and, there's a vendor who's dropping off a delivery twice a year. That's all they're doing. They're just dropping it off. No services. Are you really saying that is covered by the statutory language?
Yes, I think so. And not just by the statutory language. I think
that's
McVeigh.
Come on.
So if you have an Amazon, if you have an Amazon employee, to follow up on Chief Justice Kirby's comment, that drops off packages on a regular basis, but let's even say there are different drivers each time they do that. Every one of those, but it's in the regular course of business for the company. Every one of those drivers are going to be statutory employees of TSC for whom the packages are delivered?
Well, I guess the question is, do they have a contract with the principal contractor?
Okay, let's assume there is a contract. So if there is a contract, then it's a statutory employer-employee relationship.
If there is a contract and they're on their premises, and like I said, McVeigh said this 80 years ago.
So any contract would make it a subcontract relationship? When would you have a contract between a delivery person that would not equate to a subcontractor relationship?
We'll take the Tractor Supply example. If Stanley National hired a delivery service to deliver the product to Tractor Supply, then Tractor Supply would not be in privy to contract with the delivery company. On the other hand, if Stanley National delivered the product itself to Tractor Supply, then Tractor Supply has a contract with Stanley National. So I think it depends on the facts of the case. If Tractor Supply had a contract with the delivery company to supply it regularly with an important product for its business, then yes,
All right,
it
let's
would.
say it's once a year. It's a Christmas tree company, and they're delivering your Christmas tree, and they bring it to the front porch of Tractor Supply, and they deliver it there.
Drop it off.
Does that qualify?
So Tractor Supply is ordering Christmas trees from the Christmas tree company.
Yes, sir.
And the Christmas tree company
They
delivers
have the
it.
spirit, Christmas tree spirit.
I think
Once
it would
a year,
depend on
they
the
want that
facts.
live tree.
I think it would depend on the facts of the case. You'd probably develop a record and say, okay, what percentage of Tractor Supply's business is selling Christmas trees? Does that rise to and it might vary by store, by location.
So if 20%, is it 20%, 10%?
And I don't know.
What's the cutoff?
Right, well, that's up to the trial judge. And what's great about the current rule is that it gives the judge flexibility to
So
decide on
one
the
trial
facts.
judge could say 5% and the other trial judge could say 50%?
It's up to the Court of Appeals and the Supreme Court to decide where the line is. But I think, to go back to your earlier question when you said, Justice Campbell, you asked if a case would have to be overturned, all these questions still would dictate that McVeigh would have to be overturned, because McVeigh said a mere furnisher of goods is still a subcontractor under the statute, and that's been good law for 80 years now. And
I mean, McVeigh did rely in part on, there was another statute that had a carve-out for construction contracts, and I can't recall, if you can fill me in, but the exact nature of the other statute. But in their textual analysis, they did point to another statute that that had a carve-out for construction services, and so I think the reasoning it was, at least in part, that, well, we don't have that same carve-out here, so we ought to interpret this to, include that. Is that a distinction between this case and McVeigh? Is there a reason to treat construction contracts differently? I asked opposing counsel about the, how significant the ascending or descending nature of the contractual relationship is. Do you think that's important? Is that a factor to be considered?
Well, to answer the first part of your question, the construction aspect of this, that's never really been at issue. I do know that 50-6-113, subsection F says this section shall not apply to a construction services provider, as defined by 50-6-901. So construction services provider is a defined term under the Workers' Comp Act, right? Although subcontractor and principal contractor are not. We rely on tests, that have been in place. And as far as the ascending versus descending, what I think we have to not do, it's very tempting. I know Judge Usman did it, and the appellants are doing it too. It's appropriate to use common sense, but this is entirely a creature of statute, the Workers' Comp Act. And we have to look at what's the purpose? Like, why are we, what's the analysis about? And there's 3 policy considerations that were pointed out by the court in Lindsay 16 years ago. So it said the statutory employer rule is, number 1, it's intended to ensure that all workers will receive compensation when they are injured in the course of their employment. Number 2, it prevents employers from contracting out normal work simply to avoid liability for workers' compensation. And then 3rd, it encourages employers to hire responsible insured subcontractors. And so I think when you ask all these questions through that lens of the identified policy considerations and the fact that the legislature has had 106 years now to go in and carve any exceptions out from under the umbrella that has been created, not only by the plain language of the statute, but also by this court's interpretation of the statutes throughout the years. Consider this. Consider in 1924, the Supreme Court in the Williams case, Williams versus Buchanan. This court said that the issue came up in 50-6-113. It says a principal contractor, intermediate contractor, or subcontractor shall be liable for compensation to any employee injured while in the employ of any of the subcontractors. So as you can imagine, people still fight to this day over whether someone's an employee or an independent contractor in various types of cases.
How do those policy considerations that you mentioned, how do those actually apply here? You imagine a mom and pop convenience store and the number of vendors, right, who would be servicing that mom and pop store with the wide variety of goods that place sells. Is it actually realistic to expect that the mom and pop store is going to be able to, investigate and control, whether these vendors all have the appropriate kind of workers' comp insurance to protect their employees? It's reasonable when you're dealing with a discrete project that the principal contractor would exercise perhaps that kind of control over the subcontractors that are hired to actually perform the work.
Right.
But, we're talking about a very different situation here, aren't we?
Sure. The answer to that question is, Mr. Cook and I, we practice in Hendersonville, so a lot of our clients are small businesses, so we're pretty familiar with this. It is no more of a burden for these small businesses to put an Outlook reminder once a year to get their COIs from their vendors and make sure they got workers' comp coverage than it is to have it hanging over their heads that any of these vendors, no matter what they do, they could do everything exactly right as the premises owner. But if they have a slip and fall, then they're going to get sued and tort. Even if they end up prevailing, it's going to cost them tens of thousands, maybe 6 figures to defend that lawsuit. And they better hope they have good insurance. That's why this is a policy decision. This is not something that, some lawyers arguing over a premises liability case on a Tractor Supply store should be deciding. This is something that should be decided by the legislature. They can get economists to come in, they get insurance experts to come in, have lawyers come in, judges,
Well, the legislature
whoever.
did decide it, and we've
Right.
just got to interpret the statutory language, right?
Right. Well, is if they want to carve out an exception like this and have it applied drastically differently, this would make a huge impact on workers' compensation law.
Do you think that an exception, carving out an exception is, your opposing counsel seems to disagree with that. It seems to me that the case can be decided based upon the language of the statute. Engaged upon the subject matter of the contract to the same extent as the immediate employer. Tractor Supply had no control, or did Tractor Supply have control over Mr. Coblentz? Did they pay him? Did they set out his duties? Did he work for them? And should that enter into our analysis? This whole aspect of control.
Well, there's 3 prongs to the test, right? So the control aspect is only the second prong. It's one of 3 different prongs. And so in this case, it was decided that the first prong didn't apply. It's whether or not the principal contractor undertakes work for another entity. That didn't apply here. And then the second prong, which you just asked about, Justice Tarwater, control, we decided it may apply, probably not. Tractor Supply probably controlled the outcome to a certain extent. You know, there was a merchandise display team. They had to make sure that the national display was in accord with whatever Tractor Supply wanted at its locations. But as far as controlling the process of how Mr. Coblentz went about his day-to-day duties, no, there's no real control over that. And so that's why, you know, everyone focused on the third prong, which is whether or not, which really has 2 prongs, right? It's an either-or third prong. Was the work that Mr. Coblentz was doing, was it a regular part of Tractor Supply's business? Or was it part of the same work that Tractor Supply's employees did? And so the answer to both of those prongs in the third prong was yes.
Okay, let me go back to your point that you could contend that if we were to adopt Judge Eastman's approach, in this case, this court is making policy instead of making law. You agree with the 3-factor test that to be used, right, from the Murray and Lindsay Klein cases?
Sure, I think it's fine. I don't think it's the court's prerogative to change the test. That's kind of my point.
Well, but the court made the test.
Right.
So
right.
why couldn't the court change the test or adopt a different test without making policy? It would be simply adopting a different approach in different cases. So how's that change making policy? When we created the test to begin with.
Sure. Well, I guess I would answer that. First of all, with the principle of stare decisis, this court said, I briefed this in my brief, the Cooper case, which says that when a statute has been construed by the court and the rule of interpretation has been on the books for 12 years, in this case, by the way, was interpreting 50-6-112, which is right before, obviously, 50-6-113. It had to do with employer subrogation rights in workers' comp cases. But that court said that, it went on and on about how, you know, we have long adhered to the rule that when a prior decision has addressed the construction and operation of a statute, the principle of stare decisis will apply unless the General Assembly acts to change the statute. We've ruled on the construction and operation of the statute, and it is the prerogative of the General Assembly to change it. When the court's construction of a statute has been on the books for 12 years, the court should follow the decision until the legislature acts. And so that's what I think this court should do here. You know, stare decisis sometimes, I think, has like a negative connotation, like the court, you know, is kind of bound and they can't do something that they want to do. I didn't know what the full translation was until I started prepping for this oral argument, but the full phrase is, I think, interesting. It's actually stare decisis et non quieta movere, and it means stand by the thing decided and do not disturb the calm. So this court can stand by its existing rule, don't disturb the calm. There's no compelling reason for this court to change the rule.
What if we don't change it, but we only add that it's only applicable to services, not goods?
Right, because that would be a carve-out. That would be disturbing stare decisis because of the McVeigh case, which says that a mere furnisher.
Is it not just clarifying the application based on a plain language meaning of subcontractor?
I think that the McVeigh case, if you want to view it as like an umbrella, I think that the McVeigh case said, you know, subcontractors to be construed liberally so that all workers are covered. It doesn't matter if you're a vendor or a vendee or a mere furnisher of goods or whatever you want to call the person. They're all covered under TCA 50-6-113A. So that's the interpretation for the last 80 years by this court. And so if you want to carve something out of that, yeah, you'd be taking however they would have you do it, the vendor-vendee relationship in the context of a retail store, however you want to phrase it, that would still be coming out from underneath that umbrella, no matter how you slice it.
When you think about the different configurations that a vendor-vendee relationship can take, this one involved a little bit of work at the store. Most do not. And doesn't it make more sense to adopt a test like the predominant part of the relationship, or whether the provision of services was incidental, to see the continuum of when a vendor-vendee relationship might be on this end of the continuum, where it's more like a principal contractor relationship or a contractor subcontractor relationship, because then we don't have sort of absurd results where the provision of just barely the sale of goods delivered to the front porch creates a contractor relationship.
I completely understand the argument, and that's a very fair point, but my answer would be no, that's not a good idea. If the policy truly is of the legislature is to ensure that all workers receive compensation when they're injured in the course of their employment, then you're taking people out of that protection.
What is the relevance of the carve-out for independent contractors?
The carve-out for independent contract under 56.
Yeah, it's in, 56102, it says that a premium shall not be charged by an insurance company for any individual determined to be an independent contractor, and there's some factors to be considered. I mean,
Okay.
Has anyone argued in this case that this is an independent contractor relationship? And what do we make of the fact that, this doesn't apply to some contractual relationships, right? Including independent contractors. So, is it really as broad as you're making it out to be? Is the statutory language as broad as you're making out to be? Or is your point just that if the legislature had intended for there to be a carve-out for these kinds of relationships, that it would have done that in the text?
Yes, Justice Campbell. I think, to go back to the case I cited earlier, the 1924 Supreme Court case, that was the issue in that case, was whether or not employees of subcontractors includes independent contractors. Mm-hmm. And they ruled that, there's no indication that the legislature wanted to limit that to just quote-unquote, W-2 employees. And so they said, no, it applies to independent contractors too. And that's been on the books for 101 years. And if you want to say, well, okay, we're not talking about the actual worker, we're talking about whether the subcontractor is a vendor or an independent contractor itself, then that's covered by the McVeigh case, again. And also, it's covered by statute. That says 50-6-114. Says no contractor agreement, written or implied, or rule, regulation, or other device shall in any manner operate to relieve any employer in whole or in part of any obligation created by this chapter, except as provided in subsection B, which doesn't have to do with anything we're talking about. And that was used in Harness versus Bechtel-Jacobs, but also by Stratton. This court, the Supreme Court in 1985, said that provisions in contracts between the parties do not control in the question of whether the workers' comp statute applies, and where the facts are basically undisputed is a question of law for the courts. And so, if we went that step further and overruled that part, reinterpreted that aspect of the statute, then now you're in danger of overruling Stratton too. That's been on the books for 40 years. So, I think my point is that throughout the generations of this court has consistently interpreted the statutory employer rule broadly, I'm assuming because of the primary purposes of the rules, to ensure that all workers injured in the course of their employment are compensated. And if other states want to do it different ways, then that's fine. Tennessee can stand on its own 2 feet. They mentioned the Humphrey case, the Humphrey versus Whole Foods case in Colorado, and that was mentioned in a little footnote in Judge Usman's dissent. I'd encourage the court to read that opinion. It's very similar to what's going on here. It's a gentleman who worked for a burrito company, and they stocked Whole Foods and other locations with burritos. And, you know, he actually did some of the stocking, and he cleaned up his area, and, you know, the things that you would expect someone who's doing that type of service to do. And the Colorado court says, well, the same argument came up, whether or not this person was a statutory employee. And the court went through the analysis and said, well, if he's not doing it, then someone at Whole Foods has to do it. And so under our analysis, which is similar to our regular business test, yeah, of course he's a statutory employer. And they said that, you know, the other side has cited some cases from other states that come out differently, much like this one has. And it said those cases are unpersuasive. We're sticking with our rule. And that's what I think with stare decisis. Stand by the prior decisions. There's no reason to change it. I want to make a final point on that, on stare decisis, that I didn't get a chance to get to yet. But the court in Cooper, when it was asked to reinterpret 50-6-112, said this court will overturn a settled rule of law only when there's an error in the precedent, when the precedent is obsolete, when adhering to the precedent would cause greater harm to the community than disregarding stare decisis, or when the precedent conflicts with a constitutional provision. There's no showing of any of that. I mean, maybe an error in the precedent, but now you're talking about going back 106 years to when the statute was implemented. It's the same language as it was 106 years ago. It's been interpreted broadly by the court in Williams in 1924, by the court in McVeigh in 1945, repeatedly. It's broad. We want to ensure all workers get paid.
I'm curious, as I was thinking about the import of your argument, and this question was asked a little bit earlier of you, and I'm not sure that I fully got your answer. Isn't the practical impact of what you want us to do today is a holding that all vendors are really subcontractors?
That's what the courts have said. That's essentially what McVeigh said in 1945. Yes.
So any business that contracts with another business to sell them something, whatever it is, maybe it's a window, maybe it's Little Debbie snack cakes, or, you know, the Miller beer. Those are all just subcontracts. Those are not contracts.
Okay, right. So I think your question, it touches on something that I think, you know, Judge Usman's compared this to trying to fit a square peg through a round hole. And as I think through this, I think part of the problem is we have tended all throughout in our arguments even to focus on who is a subcontractor. How do you figure out who is a subcontractor under this statutory employer rule? That's not really the interesting question. The interesting question is who is a principal contractor. That's what the three-prong test is going for. And since we were focused on the third prong, you know, that has to do with what the subcontractors, employees, or independent contractors are doing. But the court said 80 years ago that it doesn't matter what you call them, whether they're vendors or subcontractors or independent contractors or intermediate contractors or mere furnishers, those people are all subcontractors as we interpret the statute. And the General Assembly has had many, many, many opportunities to change it, and they've declined to do so. And maybe after this case, maybe it'll get their attention a little bit. We're here in the Capitol building. Maybe they'll decide, hey, let's look at this. And who am I to say don't do that? Sure. But my position is...
We don't ordinarily place a lot of weight on legislative inaction, do we?
Well, I think so. I think under the Cooper case, it said, yeah, it's the General Assembly's prerogative to act to change it.
Well, but my point is just that we can't really infer from the fact that we can't necessarily infer the legislature's agreement with our prior cases from the fact that they haven't amended the statute.
I suppose not, but under stare decisis, I think we're still bound to follow this court's prior precedent unless they've shown a good reason for this court to change it. I think it might be my position. And like I said, the separation of powers issue. I mean, this is entirely a creature of the General Assembly. This is not rooted in common law. This is entirely, workers' comp is entirely a creature of statute. And the General Assembly is well within its ability to step in and change it. And now, if there was some other reason why, if they could show someone was in danger, some rights are being violated under the Constitution, or if it's obsolete for some reason, that would be different. But there's absolutely no showing of that. They just prefer a different rule. I think they should have interpreted it differently 100 years ago. And I would submit that that's not this court's prerogative to step in and change it now for no good reason.
Thank you, counsel.
Thank you very
Other
much.
questions? All right, thank you for your argument. Mr. Colbert? Colbert? I can't get your name right. I've known you too long. Now I'm confusing you with a late night talk show.
You're not handling the pressure really well.
You're right.
Just very briefly, I don't resort to this very often, but Black's Law Dictionary defines subcontractor as one who takes a portion of a contract from a principal contractor or another subcontractor. In a vendor-vendee relationship, you have a buyer and a seller, but I'm not sure you always have a principal contractor and a subcontractor as envisioned in this statute in every vendor-vendee relationship. And I think that's why the Murray-Lindsay test, and I think the court recognized this, we're not asking you to carve out an exception to the statute. We're asking you to decide that there may be settings where the nature of the relationship between the parties is such that the Murray-Lindsay test just isn't a good fit. And when we ask you to do that, we're asking you to join other courts with similar statutes all over the country that have done the same thing. In this case, I'm not sure how you get to the point where you say one particular party to this vendor-vendee relationship is the principal contractor and the other party is the subcontractor. When there's a contract for the purchase and sale of goods, which party is the principal contractor and which is the sub? Is the buyer always the principal and the seller always the sub? I don't believe you can try to plug this square peg of the Murray-Lindsay test into the round hole of a vendor-vendee contract and get that answer. We ask this court to reverse the Court of Appeals and the trial court and send the case back for a trial on the merits of the premises liability claim.
Thank both parties for your good arguments. The case will be submitted. All right, Mr. Hibner, you may call the next case.
State of Tennessee versus Janessa Sokoloski.